Mesdames, Messieurs, avec votre permission, on va commencer la soirée. Je m'appelle Daniel Jutras, je suis professeur à la faculté de droit de l'Université McGill. Je voudrais souhaiter la bienvenue à cette première conférence Sotos sur les actions collectives et leur impact social. Comme vous le savez, l'Université McGill est sur un emplacement qui a longtemps servi de lieu de rencontre et d'échange entre les peuples autochtones, y compris les nations Haudenosaunee et Anishinaabe. McGill honore et reconnaît et respecte ces nations à titre d'intendant traditionnel des terres et de l'eau sur lesquelles nous nous réunissons aujourd'hui. Pour ouvrir cette soirée, j'inviterai une invitée à prendre la parole. I'd like to introduce an elder, Sedalia Kawanotas-Fadzio, who is a native of Kanawake and who has kindly agreed to open the event for us tonight. Sedalia.
Gwe, wat kono hora de suwa gwe kutsi wasa wawene jochage. Negadi neganyoke hagaro di hazage. Gawano da shuchats. Wakskare wagadangana wagene the wagatajo. I said, hello. I welcome you all to Georgiage in my language, now known as Montreal. Unceded Mohawk territory. My name is Gawanodas, and I'm Bear Clan from Ganawage. In my culture, before beginning any gathering of minds, before we even begin our day, we always start our gatherings and our days by doing Ohondo Karihuadeko. And that means the words that come before all others. And the reason why we do this is at the beginning of time, when Mother Earth was created, everything on Mother Earth and everything in Sky World were given the original instructions. And to this day, everything in Sky World and everything on Mother Earth is doing everything they were instructed to do. The trees still grow. Brother Sun comes out every morning. The birds sing. The rivers flow. Everything does exactly what Sugwayat Dizo, our creator, told them they needed to do. Everything except us, the human beings. And our original instructions were very simple. Love, honor, and respect one another, and give thanks each and every day for all of creation. And this is what we'll do now. I'm going to do it in my language, but before I do it, I'll explain the prayer a little bit. At the beginning, I'll say, Onagadi agahewem de tawaroro genugat nikuna skat nikuna dawadu. And this means the time has come for us to bring our minds together, so our minds become one. And as I name the elements on Mother Earth and in Sky World, I'll say, Tokadinayo tunugwat nikuna. This means so be it in our minds. And at the end, I'll say, Onagadi toniore wakadili watkweni. Dogatenza keat dat niguno. Ize gadine suat nigunagu susasu wakwatako. And this means this is as far as I can go in my prayer. If there is anything I have forgotten in creation, I leave it to you. Onagadi nenu wadetsido onu horado nesugoyat disu. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado neungwet suma. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne yukini stahanza. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne gatne galunyo. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne gozu suadana no wala suma. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne uzino wat suma. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne hunde suma. Dano tera suma. Dano nukwa suma. Dogadinayo dunugwat niguna. Onagadi nenu wadiatin horado ne uziza suma. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni yujun heko. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni ogule suma. Dan karunda suma. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni odi do oguma. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni kaeli ni kawirage. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni yukiso togura di weras. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada tiyo disto kwarin yut kanuyade. Tukati na yo tunu kwani kura. Ona gadi nena wadi tidonu hurada ni sukwati ajoke ne kagarakwa. Tukati na yo tunu kwani kura. Ona gadi nena wadi tin hurada ni yukiso ta sutane kagarakwa. Tukati na yo tunu kwani kura. Ona gadi tunu kwadi etido wade ni kura yera tinu kwadi nesu kwaya diso. Dandeze tido wanu huradu din hodoro geru tiyo hansade. Ona gadi tuni ore wakadili wat gweni tuka tenza kea dani kuno. Ise gadi nesu wani kura kumsusa so wakudago. So the importance of this prayer is if you look around you at everything in creation, if we lose just one of those elements, if the waters decided tomorrow morning they no longer needed to flow, if those trees decided they no longer needed to provide the leaves to clean our air, all we need to do is lose one element on Mother Earth or in Sky World, and we as human beings will not survive. But if every single human being disappeared from Mother Earth tomorrow morning, Mother Earth and Sky World would thrive. So that is the importance of giving thanks each and every day. Before I go, I always like to try and welcome people with a song. And this song is one that I like to welcome people with because it's probably one of the first songs that the colonizers heard arriving on these shores. Because when they arrived, we, the Indigenous people, welcomed them with open arms. We helped them. We taught them how to survive on our land. And we probably sang them this song. It's a friendship song. Way ahead. So once again, welcome and thank you.
Thank you very much for this thoughtful and powerful opening. I will take a few moments to introduce our guests and explain briefly the order of proceedings for tonight, and then we'll turn to our speakers and address the topics that have been brought forward for today. So with us tonight, we have on my extreme left, Dr. Cindy Blackstock, who is a professor in the School of Social Work at McGill University and the executive director of First Nations Child and Family Caring Society. Dr. Blackstock is a member of the Gitxakan First Nation with 25 years of social work experience in child protection and Indigenous children's rights. She's a prolific author and, as you well know, an inspiring activist whose extraordinary accomplishments have been recognized in many ways. She holds an academic PhD in social work, but another extraordinary 19 honorary doctorates, most of which have been awarded in the last 2 or 3 years. She's an officer of the Order of Canada and a fellow of the Royal Society of Canada. David Stearns, on my immediate left, is a lawyer with the Sotos firm in Toronto and one of Canada's leading litigation lawyers. His experience in class actions extend over 20 years, and he has acted as counsel in some of the leading franchise law cases and complex litigation related to competition, price fixing, and breach of privacy. Maître Stearns is the past president of the Ontario Bar Association and a proud graduate of McGill's Faculty of Law. And even though he has gray hair and I don't, he was my student a while ago. I have less hair, though. He's one of the lead counsel in the $3.5 billion class action that was filed against the federal government on behalf of tens of thousands of First Nations children who suffered or died while waiting for help from services that Ottawa was legally required to provide. I'm sorry to say that Maître Stearns is also a proud supporter of the Toronto Maple Leafs. I will turn immediately, well, we won't hold that against you. You have to know that I'm a huge Habs fan, but that's not our topic for tonight. So I will turn the floor over to Maître Stearns for a few words about the Sotos Lecture and the inspiration for this series of lectures. This is the inaugural lecture, but there will be more. David.
Yes, thank you, Professor. And it is a great honor and pleasure to be back here at McGill, where I spent many happy years, including, I think I was one of Daniel's first students. The genesis of this program came because we had two complementary objectives. And being class action lawyers, I can tell you that one of those objectives was very selfish, and one of those objectives was very benevolent, altruistic even. And that's kind of how we operate as lawyers. The selfish one, though, isn't really that greedy selfish. It was, we wanted an opportunity to speak to the students at what I believe is the best law faculty in Canada. I think others share that view as well. That has such a rich and diverse student body. So interesting, so interested in many issues of social justice and other things. And we wanted that opportunity to speak to them before they completed what I call the zombie walk to Bay Street in their last year. And I talk to many students who are making that walk, and I try to tell them, you know, before you get to your destination, you might want to veer left, veer right. There are some interesting career opportunities for people like you. And by the way, why did you want to be a lawyer? And that always gets them to stop and pause and think. And usually the answer is because they wanted to do something good. They wanted to actually see justice in play. And unfortunately, given the realities of the world we live in, that isn't always a viable career option. Yes, you can go and work in-house, you can go work at an NGO, you can work for the United Nations, you can work in academia, but that's not for everybody. But there's actually a way in private practice that you can, I think, do well by doing good. And that is one of the things I wanted to impart on you. This case is exceptional in almost every respect, and I'm not going to sit here and tell you that this is a typical class action case. It's not, but it is certainly one of the ones that we're most proud of that exists, that's out there. So that was the first selfish objectives, to tell people this is a career option, and if you want to talk about it, drop us a line and we'd be happy to talk. The other one is truly altruistic, and that is that This case that I credit Cindy and her team for bringing is truly one of the most important cases in Canadian history, probably one of the most important cases ever to have been brought. And I remember reading about it for the first time, not in a lecture, but I think it was the front page of the Globe and Mail, or it was online in the Globe and Mail, and it said, Canada has been found to discriminate against a generation of First Nations youth. Canada's found to discriminate against a whole generation of First Nations youth. And that was why, it seems, there were so many First Nations youth in foster care, which I did know, but I didn't realize why. And so, like most Canadians, I did what we would normally do with an article like that, and I said, that is extremely important and interesting, and I'm going to get back to that and read that as soon as I get the chance. Which is why I have 57,465 emails in my inbox. And the IT people hate me. But I eventually found the time to actually go back and read it. And I was astonished at how, I guess, ignorant I was about the underlying facts and how important this case was. And at the time, I was, as Daniel said, the president of the Ontario Bar Association, and I had one great job and one great privilege in that role, and that was I could give the President's Award to whoever I wanted. And I thought, this is a great case, I'm going to give it to the team that brought that case forward, because when I heard about it, I thought, this is epic. And by the way, people should really know about this case. And so that's how I came into contact with Cindy, that's how I came to know about this case, and that is also why I think this is a perfect opportunity to teach the next generation of lawyers about this important case. I think it's up there with Brown versus Board of Education, and people should know about it, and that was why it was the privilege of our firm, and I credit my partners for supporting me in this decision, to start this inaugural lecture with this important case.
Thank you, David. As you can see, the series is already a success. The inaugural lecture has drawn a lot of attention and brought many of you here. Let me take a moment to explain the format, because it's perhaps not the format that you expected. It's a somewhat unusual format. So for the first hour, our speakers will engage in open conversation in which I will ask questions of them and they will address them, and I suspect will likely engage in some dialogue about those questions. You may also ask questions. In the first part of the conversation, you'll be able to do so in writing. We have some volunteers around the room. If you want to ask a question, just raise your hand perhaps and write your question down on a little card. Those cards will be forwarded to me so that I may include those questions in the conversation as much as possible to give everybody an opportunity to participate and clarify some aspects that they are particularly interested in. I will try to do so in an orderly way, and don't be mad at me if your question doesn't wind up being asked. I'll do my best to make room for every one of them. You may raise questions, of course, in French or in English, but I may have to translate them, particularly for Dr. Blackstock, who's told me that she's more proficient in English. We will keep some time at the end, probably half an hour or so at the end, for oral questions. So you'll see that there are microphones here. If your question has not been asked, or if you think of something else that you would like to ask, you're welcome to go to the microphones and we'll turn the floor over to you. At that point, however, I will ask you to refrain from asking questions about individual stories or stories of people you know, as our guests are unable, for obvious reasons, to address individual cases. And so I will count on your diligence in that respect. Let me add a few general notes before we begin. First of all, I would like to say that the Department of Justice and Office of the Attorney General of Canada was invited to join us tonight, but the department declined to do so because the litigation is ongoing, which I think is fair response, although disappointing for us in terms of acquiring knowledge of all angles of this litigation. Second, both Cindy Blackstock and David Stearns are speaking in their personal capacities only, and neither of them are speaking in their capacities either as representative of the First Nations Caring Society or as counsel for the plaintiff in the class action. Last thing I want to do, because you're not here to listen to me, is to very quickly summarize the cases that we're talking about, just on the assumption that we need a basic level playing field before we begin the conversation. I want to do so to the best of my ability, but obviously I'm not the best person to do that. So what are we talking about? We're talking about systemic discrimination in funding and the operation of welfare services for First Nations children and the negative consequences of this discrimination for thousands of children and their families. That's basically the topic that's on the table now. It was approached in the two cases or two aspects that we're going to look at in different ways. One aspect was a claim before the Human Rights Tribunal, and one aspect was a class action that was initiated a bit later. So in order to understand how that unfolded, I think one needs to understand the two basic arguments that were raised in both contexts, and they're pretty similar. They overlap quite significantly. So here's the argument. The argument is that for several decades, the federal government did two things simultaneously. First, it systematically underfunded prevention services to First Nations children living on reserve and in the Yukon. So very low funding for services on the reserve. And at the same time, the government fully funded the cost of care for First Nations children who are removed from their homes and placed in out-of-home care. Now, you can immediately understand the outcome of that, because the structure of that funding, so no funding or limited or insufficient funding for reserve care, significant funding for out-of-reserve care or out-of-home care, creates an incentive, a perverse incentive. And the perverse incentive was to remove First Nations children from their homes and place them in out-of-home care as a first resort, not as a last resort. Taking children away from their home environment is a last resort in general in child services, but the perverse way in which the funding was provided created the opposite outcome for First Nations children. And that, I think, is one important reason for the staggering number of First Nations children in state care. The Truth and Reconciliation Commission found, for instance, that 3.6% of all First Nations children under the age of 14 were in out-of-home care, compared to 0.3, so 10 times less for other children, non-Aboriginal children. Obviously, the incentivized removal of First Nations children from their homes has caused traumatic and enduring consequences for these children and for their families, and their lasting and terrible consequences. So that's the first problem, or the first issue, I think, which arises in those two cases. The second issue is a little more complicated, and I don't want to delve into it too deeply, because I think there'll be time in the conversation to explain what it is. But in order to understand that second argument, you have to understand what's called the Jordan's Principle, which is a child-first legal requirement designed to safeguard First Nations children's substantive equality rights. And the best way to explain this, for those of you who are not familiar with it, is to understand that there's often quite a bit of bickering between different levels of government about who needs to pay for different kinds of services, particularly, in our case, First Nations services. The Jordan's Principle mandates that the children should be taken care of regardless of that bickering. So take care of the children, decide who pays afterwards. I guess that's the easiest way to summarize this. And so that's the second argument. The second argument is that the federal government, federal crown, failed to comply with that principle over several decades, resulting in systemic discrimination for First Nations children. And so there were two avenues for redress that we're going to explore tonight. The first one was initiated in 2007, and Dr. Blackstock was a key player, initiator in this effort. So in 2007, the First Nations Child and Family Caring Society and the Assembly of First Nations brought a human rights complaint, claim of discrimination, before the Canadian Human Rights Organization, federal level human rights organization, alleging discrimination on these two arguments that I've just outlined by the federal crown in the provision of child welfare services. And after a long and difficult battle that made its way up and down the structure of courts, federal court system, complainants were eventually successful before the Canadian Human Rights Tribunal in 2016. The Human Rights Tribunal kept jurisdiction over the dispute after it had found evidence of discrimination, and over the past few years has issued, I think 9 at this point, non-compliance orders, which are essentially addresses or statements to the government that they are continuing with their discriminatory practices and need to stop. More recently, in September 2019, the Human Rights Tribunal ordered the federal crown to compensate the victims of this discrimination going back to 2006. Again, Dr. Blackstock was a key actor in this entire process, and we will hear from her perspective how this process unfolded. In parallel to this, but obviously in connection to this claim before the Human Rights Tribunal, in March 2019, a class action was introduced to seek compensation from the federal crown for the negative consequences of this systemic discrimination against First Nations children, in this case going back to 1991, so with a broader reach and scope. And Maître Stearns is class counsel for the group of victims. So I hope I did an okay job summarizing what is at stake and that everybody now understands a little bit better the 2 different strands that we're going to explore tonight. And I'm keen, at least at my end, to understand the correlation between these 2 and the ways in which that collaboration unfolded. So maybe we can start with you, Professor Blackstock, and you can tell us how you came to this case, what motivated you to initiate it, and situate us in terms of the background from your perspective.
Well, I want to situate this case in a broader stroke of history and pay my respects to the residential school survivors and the 60 Scoop survivors. Canada is a repeat offender when it comes to discriminating against First Nations children in ways that separate them from their families, in ways that strip them of their culture and of their language. And there have been, I think it's very vital for you to understand, there have been through the ages non-Indigenous and First Nations, Métis, and Inuit people who have protested this. It is not unknown to Canada. Canada knew better back then. They chose to continue the discrimination. That's been the pattern. And so back in 1997, or actually before that, I was working off reserve as a child protection worker in northern Vancouver. And I would work from time to time with First Nation social workers working on the reserve, which was literally across the street in North Vancouver. And they would tell me about all the deficits in services. And I was complaining about the same thing off reserve, just across the street. And I thought they must be exaggerating. How bad can it be just across the street? We're both dealing with the same issue. But then I went to work for the Squamish Nation, the IS Munmun program, and I was just gobsmacked at every level of where those deficits were. And they were in those areas of trying to keep families together. The basic things that I took for granted off reserve were no longer available, either through government money, and then there's the other problem, voluntary sector groups like food banks and shelters and youth services, they wouldn't come on to reserve. They said they weren't funded to do that. So you had this double disadvantage. And I remember, like, it crystallized for me in a moment where I was asked to go see a little boy who had a standing frame. And he had gone through a growth spurt, and it was being held together with duct tape. So I get the health professional to do the assessment, and I do what I would have done off reserve, which is send it in for payment. And I get on the phone with someone from Health Canada who tells me that, I've got his file open here, but he's not eligible for a new piece of medical equipment for another 5 years. I said, you gotta be kidding me. They said, no, they only get one piece of medical equipment every 5 years. I said, what is he supposed to do? And they said, well, that's our coverage, right? And I would see this time and time again, very basic, sometimes life-saving things denied to these kids. I then got a chance to work nationally. I'm not going to go into this a lot of detail, but I was naive. I thought, okay, the government, federally, surely if we show them these inequalities, we document them, we come up with solutions, they're going to do the right thing. And we did all of that. We did all of that not only once, we did it twice. We involved 5 economists, some of the top researchers. Dr. Trockmay was involved in it. And they acknowledged it. They said, that's good work. And they didn't do anything. And that's when it clicked to me that Canada uses official processes as a way to do nothing to remediate its discrimination, while weaving a narrative in the public that First Nations are getting more than everybody else, not less. And that's where the issue is, that we're ungrateful or we don't make good use of the money, not the fact that we're receiving less. So that brought AFN and ourselves to a position, what do we do next? Both of us were funded by the federal government at the time. Both of us had to make a choice about what we were going to do. And we thought about the charter option. But I'm from the Gitxsan Nation. We've seen Delgamoot, right? I've seen the Supreme Court tell Canada that things are illegal and then say, go and work it out, and it never gets worked out. So that we went the Canadian Human Rights Act route for that to try and get more specific remedies, but also because it was advertised as being kind of a user-friendly thing that someone who's not a lawyer could do. I thought, well, perfect. This is it. This is the way we're going to go at this. And, you know, it's going to be easy. And one of the first barriers we had to overcome is that the Canadian Human Rights Act at the time said that it had a section 67, that said you couldn't file complaints related to the Indian Act. But this is where having zero legal training works, right? Is I just said, okay, fine, I'm not going to write the Indian Act anywhere in this complaint, right? And miraculously, it worked. And we filed it, and for us, we lost all of our federal funding within 30 days. Then from there, a series of things started to happen. I thought they would fight us on the facts, but they didn't go there at all. It's never been about the truth. It's never been about the children. It's always been about procedure. And so they fought us. They brought motion after motion after motion. They would fail to meet their filing dates. They actually, by the time we finally got to the final arguments in 2014, we'd not only gone all the way up to the Federal Court of Appeal, we'd seen federal court 5 times by then, but the federal government was found to have breached the law on 3 occasions. And one of those occasions was withholding 90,000 records, and I found them via an ATIP, and we were 3 months into the trial. So that tells you that they were not only just willing to oppose it, they were willing to breach legal ethics and law in order to oppose it. And I think at every turn, this is what has always surprised me, is I was saying to somebody earlier on, I said, even when they hired their own expert, KPMG, to try and refute our calculations, KPMG does the analysis and comes in within 0.012% of our calculations of the shortfall. You think then you'd drop your cards. But no, not for Canada. They fight on. They were unable to find any witness, and that's been the case even since the decision. They create this public illusion, we're all about reconciliation, we accept the decision, Canadians care about this, we care about kids, and yet there's been 9 non-compliance orders. And the one in September, the hallmark piece of that is that they are fighting against 2 things. For me, the most important finding is that the tribunal found that they're continuing to willfully and recklessly discriminate against First Nations children in ways that contribute to their deaths in some cases, and their unnecessary family separations in many others. That is still going on, willful and reckless. It doesn't get any worse than that. And when you hear the minister's statements, they always talk about past discrimination. And I keep on saying, well, why do I keep on seeing you in court then? If it's over, right? The other piece is the compensation. Like I have seen, I've had I want to say a privilege, because the dignity of these people has really been just overwhelming. I don't think anyone who doesn't really met an Xavier Moucham or Marina Beadle, as we have, can really understand. But the dignity of those victims, what they went through, what they tried to stand up for, not just for themselves, but for others. And then to have Canada say, oh, yeah, we're going to pay you compensation, either through the class or through the tribunal, but at the same time file a motion in federal court to judicially review the tribunal's award of compensation, saying they want to quash all financial compensation. Like, this gamesmanship is so disrespectful to these victims who have lost so much. In many cases, the children lost their lives, and all that are left are their families to grieve them. And what are they seeing? They're seeing the Canadian government confronted by the facts, a legal finding that they're willfully and recklessly discriminating in ways that contribute to their death. And Canada still fights on.
That's a sobering account, but a very useful background, I think, to take us to the next phase. I mean, we'll come back to the Human Rights Tribunal process, but David, perhaps you can tell us a bit more about how you came to this litigation. What's the connection of your firm and yourself to the litigation? How you can tell us a bit more about the role of the representative, for instance, Xavier Mouchoum, and tell us how it's structured in the class action.
Okay. Well, as I said, I got to know the council, who I have infinite respect for, who brought and continue to work pro bono for the First Nations Caring Society, doing God's work and getting probably providential results as a result. And I was speaking at one event at another university that we won't name here because it's a competitor.
With Spirit Bears University. Was it there?
No?
No?
University?
All is good?
No.
Oh,
Okay.
yeah, Toronto.
We like competitors. You can name
Yeah.
them.
All right. I was speaking on a panel with her, and she was telling the audience about the challenges that they were facing and how the government was kicking the can down the road even after they got their landmark, let me say again, landmark decision in 2016. And I just blurted out, well, you know, it's because you should bring a class action. Because at that point, the tribunal had not rendered its compensation decision. And that kind of got the ball rolling. And we worked the case up, and we thought that there would be a very viable class action to be brought there. But we were very sensitive to the fact that we were talking about a class of children, and just recently former children, and we wanted to make sure that anything that we did not rush into a case without I guess the blessing and support of the people who had brought the case forward. And when that moment came, we jumped right on it, and I was in the great position of being able to put together a dream team of lawyers, some of whom I'm sitting in front of right now. And I chose, my first phone call was to Kugler-Candason in Montreal, who I have a great deal of respect for in the class action field. And they've brought a number of abuse cases, and very good lawyers. And they jumped in me. I don't think Rob's ever said yes faster. I've talked to him about so many cases, and he said, David, well, I'm not so sure about that. Our courts don't really care about that. He jumped on this case like before I could finish my sentence. And we've also brought in counsel from BC with First Nations background. So working together with Cindy and with some of the chiefs, we were put in contact with some individuals. A class action has to be brought in the name of an individual, or two in this case. And we were put in touch with Xavier Mouchoum, who was going to be here today. Unfortunately, he cannot. He's suffering some personal challenges right now. It's too bad. We were hoping he would be able to be here. But he signed up. His personal story is in the statement of claim. It's very touching, and you can read it yourself. I won't describe too much about his personal life, but it really epitomizes the challenges that these kids face, including being shuffled around 14 different foster homes before he was 18, and then being basically put out on the street right after that. So he's not even sure why he was taken away from his real family. So he was a perfect illustration of what has gone on. And he suffers the results of that every day, including that's one of the reasons why he cannot be here today. And we were also put in touch with Marina Beadle, who is the mother of Jeremy, who suffers from some debilitating illnesses, and who was herself really the exemplar of the Jordan's principle. And unfortunately, she recently passed away by a stroke. And I had the privilege of meeting her, and was a remarkable woman, and her legacy continues on in this case. So you asked previously about the interplay between the two cases, and that's a question that we face quite a lot. The tribunal has rendered its decision, and it's given a decision that's arguably valued at around $6 to $8 billion, I would say. Let's call it 8, and that's real money against a defendant that cannot go bankrupt, which is the best kind of judgment you can ever possibly get. Usually, the bigger the number, it's like, okay, yeah, well, when are they going to file? But Canada can't file for bankruptcy. They can just print more money. So, and they may have to for this case and for Cindy's case. But that class, or I should say that group of individuals that will benefit from the tribunal decision, that only goes back to 2006, and their maximum amount is capped under the Human Rights Act at $40,000. So the class action goes back, as Daniel said, to 1991, which is when we say the discrimination started. There's no cap under the common law. There's no cap under the charter. So we're picking up the rest of the compensation, and it will be a large number.
And I'm really happy about that because, I mean, some of the cases are valued, I think, at way more than $40,000. I mean, that's the most we could get at the tribunal, and I thank the tribunal for, you know, adjudicating this case for so long, holding on to jurisdiction and giving such thought to the compensation decision. But to give you a sense of even just some of the things that the cases are on record, and I'm not going to use the names, but some of the harm is that Canada's official position was there was no Jordan's Principle cases, even though they had adopted Jordan's Principle in Parliament in 2007. They did no advertising. They constructed a definition so narrow no one ever could possibly ever meet it. And yet, despite that, a few cases permeated the federal bureaucracy, and they ended up on these bureaucrat shelves, and therefore were disclosed to us and entered into evidence at the tribunal. One of the cases that I like to point to, it was not that long ago. It would have been about 2011. And it was a little girl that was 4 years old, and she was healthy. And she goes in for dental surgery, and something goes wrong. And she ends up in palliative care just before Christmas. The need is for her to have a hospital bed to keep her at a 30% incline so she doesn't suffocate prematurely. The request goes through 15 different bureaucrats before someone writes absolutely not. We were running a surplus budget back then. Another case, another 4-year-old little girl was passing away. Her brother had already passed away of a similar genetic illness. Canada capped the number of feeding tubes for that child and the number of diapers that she could use. And so the choice for the family was you either rewash these feeding tubes and risk infection, or you don't feed your kid. And then we had the stories like Xavier's, where kids are being unnecessarily separated from their families. And I want to kind of also just call attention to our normalization of what has happened. Like, I saw people outraged at what Trump was doing at the US border with the unnecessary family separations, but we're doing it too, and we've been doing it longer. And there's been court orders telling Canada to stop, and it has not stopped. So I think for those cases, $40,000 doesn't even hit the bucket, right? Just last week we saw, and I support this, but I'm just putting it out there as a quantum. Remember with the tragedy of the aircraft going down in Iran, Canada, the Prime Minister came out like that and said we're going to pay $25,000. Well, Canada as a government wasn't involved in any of that. And yet they are nickel and diming these kids, saying $40,000 is somehow not something Canada wants to pay, and they're not certifying the class. And so my question back to the minister, which I've asked him personally, I haven't got a response yet, to Minister Miller as well as Minister Lametti and to the Prime Minister, is if you think $40,000 is too much for the death of a child or for their family separation, then what do you think is reasonable? Right? I think it's a part of that dehumanization of First Nations kids, that they're not worth the money. That was the whole theme throughout us just trying to get the basic services, and now it's a theme in the way that they want to compensate them, is that they're not worth the money. And Canada puts out this, we're broke, or we're well-intended, but we want to get it right, which I could throw up my hands. Getting it right doesn't mean being in violation of court orders and not certifying a class. Getting it right means that they accept the responsibility for what they did. And even before the compensation order, we encourage Canada. He said, you had wronged the residential school survivors. You had wronged the day school scholars. You'd wronged the 60 Scoop survivors. Don't make these kids have to sue you. Do the right thing. Reach out to them. Accept your responsibility. And they weren't willing to do that. So it just shows how deeply embedded in the department's DNA this idea of colonialism still remains. And so I'm very supportive of the class because it can do things that we cannot accomplish at the tribunal. The reverse is also true. Thanks to the tribunal's order and to Jordan River Anderson and people like Marina Beadle, this last year alone, First Nations kids got over $2.5 billion worth of services from Jordan's principal. And we also got a further $700 million in child and family services. So those inequities are starting to be remedied, but they're far from being fixed entirely. So we need to continue to focus on that work while formulating a package that goes even beyond the money, because the money will never do it on its own. We're trying to figure out a way to make Canada stop so that we're not launching another class action for the next generation. Like, what do we need to do to penalize them?
On that point, it's interesting because you talked about the residential schools, 60 Scoop, and then this, which is called the Millennium Scoop. Yeah. There's actually an unbroken continuum. Yeah. Our class starts in 1991. That's exactly when the 60 Scoop ended. Yeah. And it really went from one terrible treatment to another. They just kept finding new ways to do it. And of course, before that was residential schools. Yeah. So we talk about residential schools as if it's in the past and it's our grandparents' generation. This is actually our generation. This is the millennium generation. And again, I started by saying that I learned about this case in the Globe and Mail, and even then I parked it to read another time. It is shocking that as someone who thinks they're fairly well informed, I could have been so ill-informed. If you read the decision of the tribunal, you'll realize just how bad it really was.
Could I ask you, I guess it's a matter of curiosity for lawyers, lots of lawyers in this room, or lawyers to be, or jurists. It's a matter of curiosity to better understand the dynamics between a social movement such as yours and the causes that it's pursuing, and the role of lawyers. And what is the ongoing dynamic, I guess, of governance, decision-making, strategic choices that are made by the two sides of that particular operation. Both of you maybe can tell us what your perspective is on that interaction between the two sides?
Well, it's really interesting because there's a real access to justice issue when you take on the government. Right? I want to give a shout out to our legal team who has worked pro bono. Some of you have seen in the press, we just released access to information documents that show that Canada's legal fees were around $10 million. Mine, being really generous with all the disbursements through the years, and we had to pay counsel in the early years, was about $600,000. So the people that represent us work for brownies and for nothing more. Because it's the right thing for kids. So it's Sarah Clark, Ann Levesque, David Taylor, and Barb McIsaac. And Naomi Metallic is going to join our team. I'm just so grateful to them. And that's
And the former judges, too.
And yeah, that's been a problem. I kind of wonder if that's part of Canada's strategy.
They keep appointing these people as judges.
Yeah, like I had these two other members of my team, and they get promoted to being federal court judges. And I think eventually that's what their strategy is, to weed them away. But that was Sébastien Gromont and Nick Mahaffey, both who did extraordinary work on this. And so what we had on our side is compelling facts and caring lawyers who were prepared to take on a case like this. Many people ran away from it because even though as you're rightly saying, a lot of people get into law because they want to make a difference. They knew this would be big. They knew what Canada would be like, and they didn't think they could afford it. And so people would scamper away on DOJ's side. And that's the other thing is I'd rather have them go to Bay Street than go to DOJ because the Department of Justice is not always just. And what I would say, regardless if you're on their side, is that you really have to set up your moral ethics about what it is that you got into law. Never forget that. Because you will always find another legal job that can match your ethics. But you have to decide whether you're prepared to do their dirty business. And we saw some lawyers who couldn't hack it on their side. They left very quickly, but there were others who held in there. And I understand that you have to represent your client. But I didn't understand what I saw to be, in many cases, really inappropriate behavior, the withholding of disclosure, all the retaliation, and all of that kind of stuff. So I think that we've had a mix of lawyers on the DOJ side. We've had some people we can talk to. But the problem has often been is they don't have instructions, right? And so we're talking to even the reasonable people on DOJ side, but they don't really have the authority to settle this. And so it ends up just percolating and burning time. So I guess my plea is don't go to Bay Street and think about class actions, but think about volunteering for crazy cases like mine, because I'm telling you, you will make a difference for a whole pile of kids. You will make zero money. But, I just find the most important things in life don't involve a lot of cash anyway.
I find it interesting and somewhat sad that this case was started by a non-lawyer. I must say, when I think about Cindy, I imagine her at her computer late at night, having worked at her job, looking up how do you make a complaint to the Human Rights Tribunal. You know, you talk about your Aaron Brockovich's, that's a living, breathing example. But why does it make me sad that it was started by a non-lawyer? Because, if you had come, I got to tell you, if you had come to my office and you'd said, I have this idea, I honestly don't know if I would have called security. I think I would have called security. I think we got someone up here. It really was audacious. You were taking on the government. It's a systemic discrimination, and you saw it. You had studied it. Others had studied it, but the rest of us didn't see it. We couldn't see it. No. It took you and took the tribunal to do it. So if there's one thing that's lacking in the field of class actions, and I say this as a class action lawyer, it's creativity, and it's entrepreneurialism. I mean, that's what started class actions. They wanted to create a generation of entrepreneurial lawyers, and it took us a while, being raised in a pre-class action era before it was ever even a thing, to get used to this idea that that's okay. You can call people up and say, there's price fixing going on, and you're paying too much for your car. Would you like to start a case? I mean, it takes a while. It doesn't sit well with you as a lawyer. You're supposed to wait for them to come to you. But that's okay, because that's how you stop people from breaking the law and price fixing. You make them pay for it. But I say this about Cindy, fools rush. The only time we'll call you a fool,
No, it's true. I knew nothing.
Fools rush in where angels fear to tread. You don't have enough honorary degrees yet. You're still, you're still a naive. But
that's why I went to law school. It didn't help.
So obviously, there's a not quite happy ending, because there's no ending to this.
No,
Right?
it's
We're
still
not
going
at the
on.
end of this. But you did get very important ruling in 2016. Can you tell us a bit more? I mean, it sounds like it was a complicated process. You described going up and down. So can you tell us a bit about the setbacks on the way to that success?
There were a lot of setbacks. I think the first one we talked about, which is my naivete thinking they're going to fight it on the facts. And I would have been okay with that, because I'm in to do right, not be right. So if they got a better idea, let's hear it. But the cutting of the funding, the multiple motions, and then finally we got through all that, and we actually were set for trial in 2009 in September. I did the opening statement, right? The tribunal chair, Sinclair, set down further dates in November, and we had our witnesses set. And within days of that, I remember I was coming from the Northwest Territories, and my mobile didn't work in a remote community I was at. But when I got to Vancouver, it was just boom, 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 loading up. And it was phone calls from our legal counsel who said a new tribunal chair had been appointed by the government, and that she had appointed herself to our case and removed Mr. Sinclair and vacated all our dates. And so there was a teleconference, and actually I was supposed to go to Jordan, to Amman, Jordan, for an event. The next week, there's a teleconference with the tribunal chair. So I kiboshed my trip to Amman, and I went on the teleconference instead. And I remember being, because I'm not a lawyer, right? I'm a social worker. I remember being on that call and being gobsmacked when I heard the tribunal chair ask Canada straight out 2 times. I think it might have been 3, but 2 for sure, whether they'd bring a motion to dismiss. And of course, they did bring such a motion, and they won that motion. So the case was dismissed, and and I also want to say thanks to the Canadian Human Rights Commission. That's where you file the case, and then they can enter into public interest. So by the time we got the decision from the tribunal, we looked at it, it was so poorly worded. And in fact, she had included exhibits that we didn't even put before her. So we had decided to judicially review that within hours, and we had and the Canadian Human Rights Commission is a wonderful organization, but it's not very fast. So when it decides to appeal a decision that afternoon and publicly goes out on it, you know it's not that great. So we had to go to federal court, we had it judicially reviewed. We had a great decision by Justice McTavish of the federal court. Canada then appealed that up to the Federal Court of Appeal. And then we went back to the tribunal. So there's been lots of this going back and forward amongst the different levels of court. And their arguments were really twofold. One is they would say, it's unfair to us, the federal government, to compare our services to those offered to other children. And I thought, well, I didn't file this case because it was about fairness for the government, right? The second was even kind of more colonial in that they said, we don't provide the child welfare services directly. We fund First Nations agencies to do it. If they're receiving lesser funds, they're the ones doing the discrimination, and they ought to be held responsible for it. So when you look at the substance of their arguments, they really are, in my view, pretty atrocious. They take their eye away from really doing right for children. And I think that's been one of the struggles in the whole case, is I actually believe in the goodness of people. And so, and I have seen many good people through the years in government, but the whole system operates like a sociopath. And if you approach it as being logical and moral, you're going to be disappointed. You have to reach, I remember one of the best teachings I had was by a maintenance worker. And I went to Mahatma Gandhi's house, and I'll make this short, but I went to Gandhi's house in India in the midst of all this. And he asked me what I did, and I told him, I vented. The poor guy got rid of a whole cigarette while I was talking. And then he finally says, oh, let me get this straight. So you work with the government, you document what's happening to these kids, it's horrendous, then you figure out a solution, they agree with it, and they do nothing. And he says, and you keep on doing the same thing. You're either talking to them by these reports or you're talking to them in court. He says, your conversation has to be with the Canadian public. And that's when we started to refine our media strategy and create this into a social movement. So I've got some here, but you can check out all the case on fnwitness.ca. And what we did is we loaded up all of Canada's legal documents, all of ours, and we invited people to read the case and make their own mind up. And it was very slow in taking on. But I think there were many people like you who read different articles or saw it in the media, and finally it started to click. And by 2012, we had so many people in the courtroom that we had to book them in shifts. And when I say people, it wasn't adults, it was children. And children really understood the unfairness really quickly. So that also put the government in a very awkward position, right? When kids of all diversities are lining up at your door to go to court. I mean, your profession isn't that exciting, right? For those of us who are not. I mean, really, bring a motion like it's all. But when you have kids there, it can be much more jazzy. So having now the public engaged in this, and having, for example, the Prime Minister asked about compensation in both the French and English debates, that is very, very helpful. But we have to make sure that we keep singing as a public, that we don't let them distract and say, look over here at all the good things we're doing. Or one of their favorites is we're talking with partners. Well, talking with partners doesn't mean they're doing anything for the children, right? We have to hold them accountable in litigation, but you also need to hold them accountable as a public and demand that they fully end these inequalities across all areas of children's experience, and that they properly compensate these victims, and that they do what's necessary to reform themselves so that they don't repeat the pattern of conduct, either the way they litigated against us. And I wrote an article for the McGill Law Journal called The Complainant that goes through some of the other misgivings that they did, either in their litigation strategy or in their way that, and most importantly, in the way that they treat these kids.
So I have a sub-question, which is really interesting to me, and I'll ask it in a moment, but I want to remind you that you're able to ask questions now, not necessarily orally, but by writing questions on a little card. Again, we have volunteers around the room who can bring you little cards and enable you to ask questions that we can weave into the conversation here. So my sub-question, I guess, and it's a question for both of you, my sub-question is the weight that is given to the legal aspect of litigation relative to other mechanisms to make the government move, right? One might imagine lobbying efforts, public communications, media efforts of various sorts. How are those things weaved together, and what is the weight of the legal side of the operation, so to speak, to achieve the outcome?
I'd like to take a crack at that. I was going to say, in terms of the interplay between class actions and social justice movements, they always seem obvious when you've brought them and when you've succeeded on them. They never seem obvious when you start them. Yeah. It requires a sort of almost like you're going to make a movie. Like, you're a producer. Okay, you got to hire some actors. You got to write a script. You got to get the cameras, and you have to think about the whole thing, because you do have to do more than bring motions. The right case can be a phenomenal failure if it's brought at the wrong time. There was a case in Ontario in the 90s that went after the tobacco companies, failed miserably, couldn't get certified as a class action. There was a case in Quebec only a few years ago, brought in part by the Kugler-Caniston firm, that got a judgment of $9 billion against the tobacco companies, and they all filed under the CCAA, the next day? Pretty much. But that's a case. So when we look at these cases, these social justice cases, we always ask, one, is it judiciable? Is it judiciable? That's the first question. Is this something that the courts can fix, or are they going to pass the buck? And if it's judiciable, is there any judge alive who's going to do it? Because it takes a courageous judge. So you've got to have the right timing, and then I think you have to have a bit of a social movement. And it's very, very timely that you should just ask that question, because we're about to start a case. I can't tell you what case it is exactly, but it's going to come out this week. And we've already got the hashtag figured out. We've got the social media campaign figured out. We got the gifts figured out. And it's against a very big company that everybody knows, everybody hates, and you're going to love it when you see it. And when you see it, you're going to say, oh, that's the case he was talking about. Oh, that's a really good hashtag. And guess what? We're going to pay 5 cents to a certain cause for everybody who retweets that hashtag. Is anybody thinking about what I'm thinking? So you need to create a social movement. It's part of what makes this job so interesting.
The one thing I'd add to that is I want to put a shout out to particularly Aboriginal People's Television Network, because this case actually involved broadcasting law, because the government did not want cameras in the courtroom. at the tribunal room at any cost. We wanted them. We wanted to be accountable. This was a public policy case. In very rare instances would we be talking about individual children, and for our purposes, we felt that that section could be closed to cameras while that dialogue happened out of respect for the privacy of that individual. Canada refused, so we actually had to go to the federal court, and federal court Chief Justice Lufty issued an order that allowed for the broadcasting of this case. And that was really epic, because this entire case, regardless of what level, from tribunal to federal court of appeal, is all on film now. So this generation of kids will never have to go looking to hear somebody else describe what happened on there. It's all on tape, and then it was created into a documentary by Eleni Sobomsawin. We Can't Make the Same Mistake Twice, and a recent one called Jordan River Anderson, The Messenger. And having the litigation, what the litigation did for us, I think, is we knew what the limitations of it were. The big win for us is that we changed public opinion in a way that this type of discrimination is no longer possible for Canada to excuse. And having the media involved, having children involved, having other types of groups kind of take up our cause and spread it through their networks, that's been part of that broader strategy, the long-term strategy. I want to win the war, not just the battle.
Could I ask, I'm getting some technical questions here, and we'll get to those. I mean, lawyers cannot escape the technical dimensions of the case, obviously. But one difficulty which I think is emerging from some of these questions is to understand the difference between addressing the past wrongdoing and compensating the victims and achieving outcomes for the future, right? And achieving outcomes from the future involves, in this case, getting the government to do something that it obviously doesn't want to do, or at least doesn't want to be told how to do in some respects. So what is the relative weight of these things, and how do you achieve that particular outcome? Is there a sense that, thank you, is there a sense that pursuing a damage claim of such magnitude actually generates leverage to obtain changes in the practices of the government? Is that how it works, or is the class action seeking a mandatory injunction or requiring the government to do particular things?
It's a very good question, and of course we're dealing with children, so we have to be mindful of the fact that we're talking about potentially a lot of money to a child, and when is the appropriate time to give them that money, and should there be any constraints on that money, and should we impose moral judgments on young adults? No one's talking about giving $40,000 or more or less to anybody under 18, let's say, but even further than that, there's probably an argument to say that there may be a trust that should be created until they reach a certain age. But those are the limitations that we have in the civil justice system. Injunctions are, that's a bit of a difficult one for a class action of this type. So it's money, and money doesn't solve problems. Money doesn't bring people back to life. When someone dies as a result of an industrial accident, they can't be brought back, but there are penalties that are paid, and there's compensation that gets paid. And that's the tool we have to work with. One of the goals of class actions is behavior modification. Some people are very cynical, and they don't think it actually works. And you could argue, based on past practices, the government's doled out probably close to $7 billion when you combine the residential schools case and the 60 scoop case. And what did they do? They were in the Millennium Scoop case. Guess what? It was third act, same play. So you could argue that it doesn't actually work, where this is an existing generation and this is ongoing. On the other hand, you got to make people pay. You got to compensate, and you got to make people pay. And that's the best that we got. I should say, however, that if there's a settlement, and there's reason to believe that there might be, you can do a lot of things. And probably one of the best examples of a settlement that actually did good was the residential schools case. People got compensated significantly. They got compensated in many cases proportionately to what they'd experienced. And they created the Truth and Reconciliation Commission, the apology in the House of Commons, which was a major act. was the result of a settlement of a class action. So to the cynics who believe that it's just about money and it doesn't really change people's ways of being, I don't know. Does it work with a corporation? Does it work with the government? I don't know, but I do know that good things came out of the Truth and Reconciliation Commission. We wouldn't be having this conversation, I would argue, if we hadn't had the Truth and Reconciliation Commission.
And I would say that I just remind us all that the Truth and Reconciliation Commission, when the hearings were held, the one consistent theme I heard is don't let this happen to our grandkids. And that's why the top calls to action are all to deal with remedying inequalities and injustices to children. So I don't think you can really fix up the past unless you fulfill that promise to them. And so that's why ending this discrimination using a combination of social movements, political strategies, legal strategies is really required. And I'm in it for the long haul. And I've said to Canada, if this isn't enough, then we'll bring a charter case against you. You know, we're going to go and speak to everybody who you want to get a Security Council seat for and ask them to do an invigilation of your human rights record. Like, whatever it takes to bring them to a place where they release themselves from the chains of racial discrimination of children, and that those means are peaceful, and that to the degree we can, respectful, then let them come. Because Canada hasn't figured out yet that this isn't about them losing to the kids. They haven't figured out that when you do the right thing, the country wins too. And even they win. They're going to save a lot of money by doing the right thing downstream.
Well, as the tribunal pointed out, what would it have cost them to actually fix the problem? It was a couple $100 million, right?
Yeah, a couple $100 million back in the day.
Yeah, and so now and that's the bureaucracy that you see, exposed, laid bare in the tribunal decision. It was evil through bureaucracy, is really what it was. It wasn't anybody with a master plan. It was just passing the buck, committee after committee, and people dealing with budget envelopes.
Yeah, and people being willing to be subordinate to bad ideas. Right. Like I saw that really, you think about yourself as a public servant. I've been one for 9 years. You make an oath towards the public. But what really played out is that the loyalty wasn't to the public. The loyalty was to the minister. And when I see the amount of butt covering that was happening in those documents, that's what we're spending our tax dollars on versus having those public servants put their eyes on the problem and solving the problem.
So let me pursue that, because I can tell
You
from
got a
some
whole
of the
pile of
questions
them over
that I'm
there.
getting lots of questions, and I don't think we'll have an opportunity to address them all, but let's try to address some of them. I think some people in the room are now scratching their heads, trying to understand what in the world is going on.
Some
right?
people literally are doing it.
What in the world is going on? It looks like it's such a straightforward claim. It looks like there's such a straightforward conclusion of systemic discrimination. So I'm going to ask you a difficult question, because it's not one that can easily be answered on your part. Putting yourself in the shoes of the people on the other side, what's going on? Why the resistance? Why not look for ways to sort this out? Is there a preference for different mechanisms for resolutions? Is the government now more favorable to let the matter drag on as a class action for years than to address it as a human rights case? What's the best argument on the other side from your perspective in terms of explaining the response of the federal government and the federal crown in this litigation?
We have something called the Spirit Bearer Plan. What it means is getting the parliamentary budget officer to cost out all the inequalities, come up with a master plan to remedy it, and then having an independent 360 evaluation of the department to figure out exactly that question. Why is it that they don't do better when they know better? And I think it really is going to take an independent evaluation of the department, because I've run through all the logical arguments on their side. So the financial piece. Yes, it's going to cost a lot of money, but we know from research from people that if you don't invest in kids, if you short your budget on kids and you create inequality, you're going to spend buckets of money downstream on lifelong costs as a public interest case. The morals thing doesn't stand up. The political heat they're taking on this, I don't know. I can't come up with a reasonable response for it. I don't know if David can with more fresh eyes. But I kind of run into a dry well. I think they've gotten into this pattern of dealing with it the same way. And they look around themselves and they see good people, so they think, well, it can't be that bad. They must be, they're just criticizing us. They're not grateful. I see a lot of expectations of gratitude from the federal government. Well, you should be thankful for everything we've done. They even on their website, they'll talk about all the services they delivered on Jordan's Principle. And there are some good employees in the federal government, but they have to recognize that was because of court order. And it was not just choosing to do the right thing. So I don't know.
I think it's the blind leading the blind in the government. There couldn't have been more pressure. There couldn't be more pressure. This was a topic of debate during the leaders' debate of the last election. This has been front page news. This has been the subject of editorials. There is a lot of pressure. And we had a very strange development in our case just about a month or two ago. Actually, it was back in November. The government was seeking to judicially review the compensation decision in the tribunal case, and obviously they lost in an epic way in the tribunal, so they figured they could only do better by challenging the decision in federal court. On the morning of the hearing, to stay the tribunal's decision, to get them to just sort of pump the brakes while they argued the judicial review, the Attorney General announced that they're deciding to play ball in the class action and that they weren't going to contest certification with a view to coming up with a global resolution. Well, I mean, obviously, timing was a little suspicious, but, you couldn't really fault them for doing that. I mean, that's not typically what we hear. It was a bit odd to get a call that morning, but we thought, okay, well, you know what? We're not going to fault you for doing the right thing. There was some skepticism that they were looking for a more friendly venue, perhaps. They were forum shopping. I think those are the words. And even my mother said, David, do they think you guys are the weak link? I said, no, Mom, why would you say that? God, you know me better than that. So, but anyway, we just thought it was odd, but we thought, fine, good, let's talk, let's settle, let's get money paid out. But then they decided they weren't going to consent to certification. So after they announced it publicly, they're now not consenting to certification. So we're going to have a hearing in September, which is the normal way it goes. It's just not normal to have the Attorney General say, we're going to consent. So they're flip-flopping. I don't know if they know which way to go. Which way to go is obvious. They need to actually sit down with both our side, with the tribunal side, and come up with a global resolution. And I wish the Attorney General, and I invited him personally he's obviously a professor at McGill and almost a classmate of mine. I have a lot of respect for him, but he declined. He said it was because of his ongoing litigation. I just don't think he wanted to be in the same room as Cindy.
Well, I'm involved in a lot of ongoing litigation, and I'm here, right?
Okay, so let's take, that was a difficult question. Maybe people in the room, when we open the floor, will want to propose some explanations. I think there may be some, but they're difficult to find. Let's take a moment to address, I'm going to ask some questions en rafale, as we say in French, like quickly, that are more technical in nature. So one question perhaps for you, Professor Blackstock. How did you document the discrimination? What's the social science part of all this?
Well, we actually, those two reports that were co-funded by Canada really were the base of our evidence. We filed it. So we got, the first time we did it as First Nations and the Government of Canada, we employed some consultants. But we got the recommendations, and when they didn't do it, we were a little suspicious, so we thought we better line ourselves up for some possible litigation even back then. So we said to Canada, look, we're willing to sit at the table for you, but we want to pick the researchers, and we wanted to pick the people who were top in the business. And so that's what we did. And we were able to get people like John Loxley, who's a fellow of the Royal Society and an economist, to deal with that. And that's why KPMG, when they tested his report, came within 0.012%. And then what we did, because we were broke, we were cut, we didn't have any money, this is where the kind of entrepreneurial stuff comes in. I just wrote to the Auditor General. I said, Auditor General, see that, you have to look at public policy. Can you take a look at First Nations Child and Family Services? This is when the case is running. And they did. So then we were able to pile on that report. Then we went to the UN and got those reports and child advocates. The most valuable piece of information I got was through access to information. And I recommend everybody uses access to information. Do not rely on disclosure when it comes to the government. Because we got this disclosure when we were about to go to trial in 2013. And the lawyer had explained to me that they have to disclose everything. It just looked like it was full of holes. So I filed an access to information request. And lo and behold, 3 months into the trial, we get this DVD with 4,000 highly prejudicial documents. We send it over to the AG and they say, oh, we're just getting those together for you. And by the way, we have 90,000 more, right? So use access to information as a mechanism of obtaining information from the government and go after their briefing notes, their communications notes. Those are where that's where the big money is. And look for all the drafts.
Okay, so that's the first quick question. Second one for you. On class actions, obviously, you need to define the group so that people understand that they're part of the group and can seek compensation if you're eventually successful. So how do you define that? I mean, the nature of the claim is discrimination. It rests on self-identification in some respects. How did you define the group in this context?
There are two elements to the class. One is the on-reserve class, and that is anyone under the age of majority in their province or in their territory who was removed from their home. Is it over-inclusive? No. That's the class that we're after. And it'll be up to the court to find whether or not all of those individuals were the subject of the same discrimination, whether certain of them may be excluded, but that's to be decided at trial. The more challenging class to define is the class that was prejudiced by Jordan's principle. I'll give you the official position of the plaintiff group, and that is that those individuals, there is anyone who was the subject of a delayed or denied treatment or product or service of the federal government who is First Nations is a member of the Jordan's Principle class. The government wants to whittle away at it. They say that there was no Jordan's Principle before Jordan River Anderson passed away, which is when it got the name. But we said, well, then wasn't he the victim of discrimination? And they kind of said, oh, yes, right. Well, that's a good point. We say it actually pre-existed. It was a pre-existing legal duty. It wasn't created by anybody, but it was recognized by Parliament unanimously, I think it was 2007, and that's when it was given its name. But the principle is one of long-standing common law, which is when you owe a duty to someone, you can't bicker with someone else about who pays for it. If someone owes the duty, they've got to make good on that duty. So we say it's just a long-standing issue of common law, but that'll be decided in the trial.
So where are we at now? What's the status of these cases? You keep getting non-compliance orders, and they don't seem to do much.
Well, we got $3.1 billion out of them
You got
per year,
yes,
right?
you got a very significant judgment on financial compensation, but not much.
Oh, I mean,
movement.
on the service side, though,
On
we've
the
been
service
getting
side.
that, yeah. But it's not fully done, so we've got 4 orders are currently under reserve at the tribunal, and we have about 18 other items that still need to be resolved to end the discrimination. Then we have Canada is still pushing forward with this judicial review, and I really recommend you read their court documents on fnwitness.ca, because what you're going to see there is they're arguing irrevocable harm, but not for the victims, for Canada. So take a look at that. They're pushing forward. We don't have court dates on that yet. And in the meantime, they lost their application for a stay on the tribunal's decision. The tribunal's September decision charged the AFN and ourselves in Canada to move forward and develop a process for the distribution of that compensation. Canada has pushed back the dates on that a couple times, and that's going to be on February 21st. So watch, put it in your calendars, go on to fnwitness.ca on February 21st. And I don't know about all of you, but I definitely plan on being in Montreal the dates of these trials. And all of us should be there, and we should be telling our friends and neighbors, and we should be alerting the media that they need to cover this. Because these kids are important, the justice is important, and we have to marshal every possible strategy we can have to make the discrimination stop.
So how attentive are the two decisional structures, if you like, or dispute resolution structures to one another? Do you find that the Human Rights Tribunal is sensitive to the fact that there's a class action proceeding?
Not
and,
really.
And vice versa?
No, I mean, and I think that's the important thing, is that government has sometimes put out, or at least a perception, that it's an either-or type of the situation. I don't approach it that way. I say it's a yes and that the human rights damages are a special award under the Canadian Human Rights Act.
But let me ask, if I may interrupt,
yeah.
let me ask very concretely, right? So there is a 2016 decision from the Human Rights Tribunal that orders compensation, and you're going to have to think about a mechanism for administration of claims, distribution of these. Is it conceivable that the government can now stall by saying, well, you know, we have a class action, there will be a claims resolution process there as well. We're not going to have two separate claims resolution processes. There should be a single
Well, that
one.
was effectively their argument on the stay
Yeah.
motion, and they lost. And the great thing about the stay motion is they put in their written materials all the reasons why a class action was such a great idea.
Yeah.
So it'll be really interesting to see them show up on September 14th in federal court in Montreal to argue the opposite. But that's unfortunately kind of how they've played this thing for quite some time.
Yeah.
Okay, now's the time for you to ask questions. Anyone wants to go to the microphone and ask a question that's not been raised? There's still plenty of time for us to have a conversation. Mr. Hernandez, microphones are over there. It's important that you go to microphones because we have friends watching us live.
And is this going to be archived?
I hope it's going to be archived.
Okay, well, we'll find
It will be archived.
It
I
will
hope.
be archived.
Yes.
Okay, good.
Please, go ahead.
Thank you so much for these insightful presentations. A question relates to the issue of perhaps not one that was raised here, but definitely intimately connected, water rights. And we understand that water is a crisis in many Aboriginal communities. I'm wondering to what extent both of you, Professor Blackstock and Mr. Stearns, would relate Canada's decision to vote against water as a human right at the United Nations during the Chrétien Prime Ministership with the issue of water rights in Canadian Aboriginal context.
Well, actually, I see Naomi Metallic has written an interesting paper about the potential of the Canadian human rights decision to remedy some of these inequalities, including in areas like water. Canada discriminates in the provision of almost every public service. I would actually say every public service. I haven't seen evidence that they've actually are equitable in any service yet. So the possibility is there to bring a human rights action against Canada for discrimination in the provision of water. And there's also, I think, a possible charter action there. The problem remains the same, is that it's an access to justice question. Who out there has the resources to be able to take on Canada and take on the retaliation that will come, either in the form of funding cuts, not getting services, in order to bring these cases? And that's why we've gone to the place of the Spirit Bear Plan and asking the public to force the government to adopt that plan. They won't do it. They don't want to call on the parliamentary budget officer to cost out all these inequalities because they don't want to remedy all the inequalities. They don't want to evaluate themselves because they don't want to have to reform themselves and face up to the fact that they have racially discriminated against these kids. So I think that we have to get away from this equality by program piece to equality as a substantive equality as a fundamental right across all services that First Nations, Métis, and Inuit peoples live. And I'm not sure legally how we get there, but I'm interested in I'm interested in trying, and maybe some of you have some ideas.
Mm-hmm. The issue, though, was more to do, my question, I'm sorry if I was not so clear. During Chrétien's prime ministership, Canada voted against water as a human right at the United Nations.
Oh, yeah.
And that was, the broader context was to do with a Canadian company wanting some water reserves in Bolivia to derive profit from that. And that led, of course, to the election subsequently of President Morales. But I'm wondering if that was if the Bolivian angle was a kind of pretext, and actually what was going on was also the water rights issue in Canada with Native Aboriginal communities.
It's definitely possible. We know with the UN Declaration on the Rights of Indigenous Peoples that Canada was one of 4 countries that voted against it. And the history that's not told as well is that Canada was in opposition to the Universal Declaration of Human Rights in 1948. and had to really be dragged to ratifying it by Eleanor Roosevelt. And one of the reasons was that they still had the Indian Act in residential schools, and that would be problematic for them. So you see these Canada using the imagery of being a champion of human rights, but when it gets in the way of what they want to accomplish, sometimes that kind of fades away. And they do bring in other countries to legitimize that.
But I can't be in this hallowed ground without mentioning that the United Nations Declaration of Human Rights was drafted by a McGill professor by the name of John Humphrey, who was still alive when I was here, and source of great pride for McGill.
Yeah. Yeah, I mean, it's one of the things to feel good about. Now we need to make it real.
Let me put a different angle on the table. I mean, so unless I'm mistaken, last spring, so before the last election, the government introduced legislation in the House to reform First Nations Children's Services. Am I mistaken on this?
No, you're right about that.
So where are we at on this? Is there new legislation in
Yeah.
the new Parliament? And are you hopeful or not hopeful?
Well, Canada, in the midst of all this noncompliance, brings forward a process for the Act respecting First Nations, Métis, and Inuit peoples, our children. The idea is to affirm First Nations, Métis, and Inuit self-government interests in child welfare. Does it succeed at that? Some will argue that the language is strong enough on that point. Where there's absolutely no argument is that there's zero money to implement that law. The federal government refused any submission we made to positively put in a positive funding obligation for the federal government, or to incorporate things like Jordan's Principle and the CHRT funding principles. So the other thing that you need to know is that First Nations actually developed their own act. When we heard about this rumbling, people, and I want to give respect to Mary Teegee, who really led that work along with Paul Siemens out of Goodman's in Vancouver, went around the country and developed a First Nations Act that would have, I think, is much stronger. And it's on our website, you can go check it out. Canada totally disposed of that. And they said, no, we're going to go this Indigenous route. And in doing that, they used it for cover. They said, no, we can't include Jordan's Principle or the CHRT decision because that's regarding First Nations kids. So we can't, that'll leave out the other people, right? And I'm thinking, I don't think the Métis would really argue against substantive equality. But that's the way they played it. So now it's law, it's been adopted. It came into force on January 1st. But as you probably know, the Quebec government has brought a constitutional reference on that. So we have until the 14th to file our intervener status. We've heard other provinces are thinking around the same thing, is that they see this as a challenge of provincial lawmaking authority under the Constitution.
Is that done through, I'm sorry to interrupt, but is that done through reference to the Court of Appeal of Quebec?
I think so, yeah. This is where my technical stuff kind of drifts off and where my legal naivete rolls in. All I know is we have legal counsel and we'll be looking at that thing. Okay. And I will now be learning about constitutional law, added to my repertoire.
David, what do you think of that legislative hope from your perspective? What impact does it have potentially on the class action?
It won't have any impact on the class action, and it's a little outside my area of expertise. But I will say one thing, because we were talking about class action impact today, and it may be of minor concern to everybody here because it happens in Ontario, but the Ontario government has actually brought forward a bill called Bill 161 that's going to very significantly restrict the ability to bring social justice class actions like this, because they're really tightening up the preferability requirement, and they're going to make it essentially impossible to bring a case where you have cases of individual suffering. So as long as everybody was overcharged by 25 cents, that's everyone's the same. Okay, great, preferable, yeah, no problem. If people were actually affected in a significant way, like in this case, then you may not get certified as a class action. So that's a problem, and I think that the goal here, the lobbying that went on to the government was epic. The banks were lobbying. The U.S. Chamber of Commerce flew in its delegation to lobby. This was a real concerted effort to make a foothold in Ontario to push back class actions, particularly and ironically ones that relate to individual suffering, whether it be prisoner abuse, solitary confinement, First Nations. Those are going to be the ones that are going to become impossible to certify. And we're already having to make plans to essentially either litigate in other jurisdictions or not take on cases that we would otherwise take on. And I'll also mention that in Ontario, when you bring a class action and you lose, you pay. That is to say, the lawyer pays. So that is a very significant barrier to access to justice in Ontario, which does not exist in the federal court and only exists to a much lesser extent in Quebec. But let there be no mistake, these parties that lobbied for this change to the law are going to try to bring it forward in other provinces.
So what do you think, this is kind of a bleak picture, but what do you think of the possible fate of claims that would use or leverage class actions to achieve environmental justice, for instance? Is that going to have the same kind of fate as what you've just described?
It is possible. I mean, plaintiffs' lawyers have had to be creative. A lot of the jurisprudence that's developed, you wouldn't have necessarily thought it would develop. For example, I remember when the residential schools case was being litigated at the motions court level, and I'll admit I was very skeptical. It really went beyond what I thought could be achieved in a class action. And I remember chatting with one of the lawyers for the defense, and he said, "Oh yeah, we got a class action about whether people were assaulted or were abused 50 years ago, and all of them to greater or lesser degree. Some of them are alive, some of them aren't." And I thought, well, I'd rather be arguing your side of the case because I think you're going to win, not because I thought it was just, but because I thought he was going to win. And when the Court of Appeal came out with this decision in Cloud, that was really what blew open the door to class actions, because the court said all those issues can be dealt with in a class action, but they can be dealt with at a later phase. What's common is what we're going to focus in on in the class action. And that's why we have residential schools, 60 Scoop, and now Millennium Scoop.
We have a question here, the microphone.
Hi. So my question is for Dr. Blackstock, and I'm wondering, knowing what you know today, if you were to redo this whole process, would you have gone through the CHRT, or would you have used a different legal mechanism to get where you are today?
It's a really good question. I've actually asked that myself because it was supposed to be quick and easy, right? Turned out not to be. But I actually think I would. The reason is because of the specificity of the orders. That we were able, I don't think with a general order, I think we would have had a lot of difficulty. We've been doing a lot of litigation after it if something went to the Supreme Court under a charter violation. I do think now, though, is it definitely the time to bring a charter case, because we have the public attention. Just about every judge in a federal court has dealt with our case, so they already know it, right? So I don't think it's as risky as it might have been 15 years ago. I do think that the time is right to think about a charter case and to end with the goal of ending those inequalities in broad strokes. And particularly, the other thing is that the public is now more aware. And so back in the day when we filed this case, most people thought we were just trying to get more money for chiefs. That was a frequent thing that we would see and hear. People would say, well, you don't know how to manage your money anyway, and all you want is more money. And the media wasn't paying a lot of attention to it. But all of that, thankfully, is really starting to shift. So if I was to do something new today, I would file a class that built, or file a charter claim that built on the good decision we have at the CHRT. And the other thing I would do over is I'd actually have a lawyer look at the complaint. Maybe I wouldn't, because maybe they would have told me there's no reason filing it because they're prohibited by the Indian Act. But it would have been a good idea to have someone look at it.
Hi there, thanks. Hello?
Yes.
Is this working? Great. Thank you very much for your excellent presentations and comments. I guess I have one quick question, and perhaps you can't speak to this, but to the extent you can, it would be great to hear your answer. From the claimant's perspective, how are they seeing this process unfold? I guess either the statutory route or the class action route. How are the claimants sort of seeing the promise of law? Is law living up to what it can achieve? Are they obviously frustrated with all sorts of issues, to say the least? So how are the claimants seeing this process? Do they see the law as a tool for change? Do they see it as another roadblock in a long, terrible history? Any comments you can offer on that would be great.
We actually, one of the things we did in the process is we immediately brought together 17 First Nations Youth in Care to advise us on what that process should be. And what we heard from them is kind of twofold, is that some of them had seen some benefits from the tribunal's decision already, and they knew that would not have come without the law. So they had some hope, but they also saw that Canada was continuing to use it as a spear. And they didn't understand why they would do that. Why would they want to hurt them, continue to hurt them, especially on the heels of residential school and the 60s scoop? And, you know, I think that's a question, right? Is why does Canada still fight this? Why do they fight on? And what is it about the law that allows for that? And one of the things that I think the law is far too generous on is this idea of fairness in terms of, well, yeah, we'll give them an extension so that they can consult with the cabinet or whatever. Like, that can go on forever and ever. And while that is playing out, the real irrevocable harm is playing out for these kids and their families, right? So I think there's some hope. People have never seen this kind of broad straight change before, but there's some rightful skepticism, and especially given the flip-flopping that people are hearing on the media, right? They're saying one thing and then doing something else.
Please come to the microphone.
Yeah, you mentioned residential schools in the 60s. I'm from the 60s and 50s sort of thing. They were there. I go to the Toronto. They have a PDAC, and Phil Fontaine, AMF, he's there in plenary sessions, and he's telling us, you know, let's say the Harper or whoever government gives them $10 billion. But it's not for them. $9 billion is putting their people to build the schools and all the rest of it. Not well built, by the way. I'm an old engineer. I can recognize a school when the roof leaks after so many few years. And Phil Fontaine was saying there's 100 schools that the roof leaks out of the 600 reserves. It was incredibly how every year he pounded on that. And it was ignored. Now, that goes back maybe to another era where you guys aren't involved, but I lived through that. And it's just more of the same now. So was Phil Fontaine, is he still involved? Because I understand he's around, isn't he?
He is around. He's not he's no longer national chief or involved politically. But certainly he has kept up to date on what's happening in our case. And the other thing I want to remind you is actually the Parliamentary Budget Officer did a review of the condition of First Nations schools and found that not a lot has changed. And one of the reasons is that Canada has a cap budget for capital, and they don't increase it enough to keep up with inflation or maintenance or anything else like that. And in fact, that's one of the issues that's still under reserve at the tribunal, because Canada refused to fund capital to offer the prevention services or offer group services under Jordan's principle. And many of these communities have housing crises, so there is no facility, or the facilities that exist, as you're quite rightly pointing out, are dilapidated. So Canada is saying no to major capital, so we actually litigated that in front of the tribunal, so that's one of the decisions that's coming out. And although I hope it isn't true, I hope I'm wrong, I think that what will happen is that the decision, I think, will be in the kids' favor, and I think Canada will judicially review that as well.
Thank you.
Thank you. So we're getting pretty close to the end of the time that's allotted for the event. I wonder if I can ask one final question of each of you, and it's the question of optimism. How optimistic are you that you will succeed in the end?
In a year?
Well, time frame is a different question, and maybe, David, you can't answer that question, because if you say you're not optimistic, perhaps helping the minister on the other side. But how optimistic are you that this can be remedied within a reasonable time frame?
Well, in terms of the case itself, I'm very optimistic. But pivoting a little bit towards the theme of this lecture, which is class action impact and how do social justice class actions fit into our regime, am I as optimistic? I would say that certainly within my experience in class actions, we've gone from class actions being viewed with skepticism by the judges. What do you mean you're not getting paid? Who's your client? How many people have you signed up? Ridiculous questions like that. Contingency, I don't know, we don't do that stuff here. Oh, wait, it's in the act? Oh, okay. Yeah, go on, what were you saying? You've seen a very significant change in the judiciary, probably because we've had luminaries like former Chief Justice Winkler, who kind of championed the area and who were viewed as heavyweights on the bench. And then we had Justice Gouge in Cloud in the Supreme Court being very, very pro-class actions. I now am seeing a bit of a backlash with Bill 161. We're always battling public perception. There's always cynicism. In a case, we have to live with it. We have to always do the right thing, be seen to be doing the right thing. So as far as the future for social justice class actions go, I think it's always a bit of we're going to see how far we can push it before we get pushed back. And I think we're seeing cases that are pushing it very far. We're talking about solitary confinement cases getting certified, prisoners' rights, LBGT cases moving forward. I'm an optimist. I hope that for the next installment of this lecture, we also can speak about successes, continued successes, and plant the seed of optimism in future students and class action lawyers.
I'm really optimistic, Jay, because I really think the past is the best predictor of the future. And in our case, I think we're close to 20 orders now. Canada won one, and it was overturned. So I think that things are looking good for the kids. And I also think that the most important thing is, when we went and argued this day, there had to be about 50 reporters in the room doing a scrum. They were there all that day, all the next day. And having that public attention and the questions in the debate, and all of you even spending your evening with us today, 10 years ago, this room would have been empty. There might have been just a couple of us here. Maybe the elder and I would have been here. That would have been it. So seeing this growing thing, I'm feeling really optimistic. The question will be is how many children are going to lose their lives in their childhoods while Canada wastes time resisting what it should be leading and championing, which is equity for kids and doing the right thing.
Thank you. I think we will end here. This is a good moment to end and a good note on which to end. Ça augure bien pour l'avenir, je dirais, pour les prochaines conférences Sotos. Keep your eyes peeled. I think there will be exciting events on an annual basis, David. Is that the expectation? I hope it's the expectation. And I hope to see you again at the next Sotos Conference on Class Actions. I want to thank, on your behalf, our guests and speakers, Sedalia Kawernotas Fazio, Cindy Blackstock, and David Stearns. And thank you for being here tonight.